Welcome to our channel. Today I'll be talking with you on how to review a contract together with your lawyer. Once again, a little bit about our law firm and myself. We are a boutique law firm in New York and California. We work on business transactions, intellectual property, and business dispute resolutions. I am a corporate lawyer by training. I do corporate governance matters, mergers, acquisitions, commercial loans, joint ventures, fund formations, and general commercial contracts, which will be the focus of today's topic. And first off, so what kind of lawyer will you need when you have a contract to review? It depends really on, to a very large extent, the subject matter of the contract. For example, for the purchase and sale of real estate, you need a real estate lawyer. For a prenuptial agreement, you need a family law lawyer. And even within the sphere of business law itself, it is the best if you can have a lawyer with the relevant experience. For example, the American Institute of Architects has a series of contracts, such as owner contract agreement, owner architect agreement, owner construction manager agreement, with detailed exhibitions such as method of calculating areas and volumes of building. So you can tell there are a lot of critical details here, and a lawyer who has experiences working on this specific set of documents and the substance, of course, embodied in this kind of document will clearly have an advantage over a lawyer who does not. And this kind of lawyer may be much more expensive, but it will take him or her much less time to get up to speed and deliver the service that you actually need. So in my opinion, there are four things your lawyer should do for you. The first task of your lawyer is to ensure the legality and enforceability of a transaction covered by the contract. For the starters, right? Is the whole contract lawful? Or does it violate certain rules, regulations, or even outright violating laws, right? For example, there are companies out there that are trying to treat their employees as contractors. You know, the tax and common laws have a lot of criteria, relatively speaking, objective criteria to determine whether a person working for a business organization is a contractor or employee. And by giving the employee, you know, a form document, and you do not really necessarily make him or her a contractor. And is it legally valid and enforceable? For example, if you receive a stock option grant agreement as an employee from a company, your lawyer actually needs to conduct a due diligence investigation. He needs to get all the proper documents from the company to make sure that the company has actually got a valid stock option plan under which options could be issued to your client, to the employee or the consultant. And the second task of a lawyer is to ensure the job is consistent with the commercial understanding of the parties. If there's a term sheet that you want to pull it out and review it, make sure that you know the first job served upon you by the other lawyer, the lawyer from the other side, or the first job produced by your own counsel is consistent with the commercial agreement you have reached with the other side. And you need to go over the contract paragraph by paragraph with your lawyer. If you're interested, you should watch my other video describing how to work closely with your lawyer and how to find a good lawyer to work on your matters. You need to pay particular attention actually to the exhibits of the contract. After you went over the contract paragraph by paragraph with your lawyer. And you should really understand the substance of the contract. it's not solely your lawyer's responsibility. It's always a teamwork. It's always teamwork. For example, you have a wind farm construction contract, right? You really need to look at the scope of the work, which is usually an exhibit of the contract. For example, is the wind farm construction company supposed to build the private road from the public road to the wind farm? And occasionally that could be, a few $100,000. And so you think you have shaking the hand with the, construction company's manager, and you have went to the side, both understand what, should be done. But again, confirm that, and a lot of substance may be reflected in the exhibits. The third task of your lawyer is to improve your commercial deal to the extent possible. And what do I mean by that? Even if you have a term sheet, there usually are details for the commercial terms to be ironed out, such as payment terms, right? If you are supplying goods to people, whether it's 30 days, 60 days, 45 days, and if there's late payment, whether you could impose interest or penalty, right? It's commercial term, right? That people who initially, discuss the business people discussing the deal may not actually have worked out all these details. And you, depending on a lot of factors such as negotiation position with a client, you may actually get a little bit more economic benefit out of a contract for your client. And there may be room for mutually beneficial arrangements. For example, if in an employee sufferance agreement, if an employer pays legal fees directly to the counsel of the employee, right, the employee will be spared from the hassle and challenges of claiming her own legal fee if she pays her own legal counsel by herself as tax-deductible expenses. Whereas such a arrangement does not really cost the employer more money. So the employer could take, from the total sufferance payment, right, and use a portion of that to pay the legal fee. The employee is supposed to pay her lawyer anyway. And the fourth thing your lawyer should be doing for you is to improve your legal position to the extent possible. And for example, in civil lawsuits in the United States, usually the prevailing party cannot recover its legal fees and costs from the non-prevailing party, unless the party agree to do so in advance. Now, imagine you are a small architect firm and your client is a very litigious developer, real estate developer, that bullies small vendors into offering discount just by resisting to pay, to pay pay the invoice, right, after the work is done. So if you have such provision in what I would describe as the legal terms of the contract, then your lawyer has empowered you, actually, if necessary, to take on a larger organization. If it try to bully you, try to take advantage of you, try to squeeze you into offering discount when they have no factual legal ground to do so. So those are the 4 things that I think your lawyer should help you with when reviewing your commercial contract. Thank you for your time, and this is today's topic.